So now, as many of us have done, we've gone through the legal path, and your case basically, you get your judgment, you get your parenting plan, and now you would like to appeal because you disagree with it. Let's move the conversation to what is, in your opinion, the role of the appellate court and the interaction between the circuit and the appellate, and even the Supreme Court, where you would like things to go, and how you recognize their current role as you see it.
Well, thank you, Jeremy. That's a good question. I happen to work on appeals as well as trial level cases. I take on cases from clients who want to hire me specifically as an appellate attorney. I've also appealed for clients I represent at the trial level. I've been doing that combined for about 10 years now. The one thing, and this is something that Jeremy pointed out yesterday, the appellate courts focus almost exclusively on two things: what the applicable statute says, and how prior decisions have interpreted that statute. They give a lot of deference and don't pay a lot of attention to the minutiae facts and details that went on at the trial level. Yes, they can be provided a transcript, and by the way, if you are going to go to a trial, make sure, just as a side note, you hire a court reporter or somebody who can transcribe the trial, because without the transcript, the appellate courts are almost powerless to overturn any ruling you might not like. But aside from that, if the appellate courts in your state have a statute that makes 50-50 the standard, the presumptive standard, it's going to make any deviations from the trial court from that 50-50 come under a severe microscope. Because when an appellate court reviews a legal error made by a trial court, that they misapplied or misconstrued a statute, they get no deference. It's called de novo review, like they're reviewing it for the first time. As opposed to, well, the trial court applied the statute correctly but came to the wrong conclusion because we might have ruled differently considering the facts. There's still, in that situation, when the trial judge makes a factual conclusion that may be wrong, that trial judge is given a lot more discretion because appellate courts do not want to re-weigh the evidence. When clients hire me for appeals, of course, they're not as knowledgeable as the case law or the statutes. They're almost always telling me about, well, this came out at trial and that came out at trial and I said this. Yeah, that can be important, but that's probably not going to be your winning ticket. What's going to be the winning ticket is a judge on the final judgment not applying the correct legal standard. When a 50-50 presumption is the legal standard, hopefully there won't be as many need for appeals because trial judges will be scared to be overturned. That is something that does rein in trial judges, is a fear of being overturned. However, under most states, they're given almost complete latitude because most of their decisions are going to be factually based and not legally based because of the discretion they have. So, long story short, a 50-50 presumption will make it, well, I think will make trial courts less likely to go off on their own and more likely to adhere to that standard because they know they can be easily appealed and overturned.
Yeah, I don't really do appeals. I don't have a whole lot to add on this other than two factors. To me, it always comes down to a cost-benefit analysis. A lot of times I'll tell my client, well, the problem with family law is the never-ending appeal known as the modification. I mean, all I got to do is come back in 4 months or 6 months and say, I got to change circumstances. No, you don't. Well, we're going to litigate that for another 6 months. So I just make an analysis of, do you need to appeal versus just take this up on another modification, with the exception being a rogue judge or a judge who's not applying 50-50. You've got to get the parenting plan that you need right from the start. So if you need to appeal, then you should, right away.
I have some faith in the Court of Appeals. Sometimes you write an appeal and I wonder if they even read it. Did they even read this appeal? Because it is so clear. Just a quick story. We had a custody case, and it was the child was 18 months old. So we the best that we could. You know, we went down the statute, the best interest, we hit every factor and brought in witnesses. I mean, it was a great case. The mothers did not have any witnesses, and her testimony, and I'm not joking, she didn't talk about the child one time. She talked about herself the entire time. The entire time. So an appeal based upon the best interest standard is extremely difficult because there's so much latitude. We filed an appeal, great transcript, right? Court, of course, didn't, they didn't issue an opinion, they affirmed the trial court, which was impossible. It was impossible. From the mother's perspective, she literally had no evidence, nothing. So there's times where you just get frustrated with the Court of Appeals because you say, did you read this? And by the way, they do not read everything. Their clerks will read some things, give some summaries, but my understanding, they do not read every appeal that comes in. Now, there is a cost-benefit analysis, there is. But got two lawyers sitting back there and tell you the majority of our appeals are either for free or greatly reduced. Because I've been so angry after a case, and I tell the client we're going to appeal. He said, I can't afford an appeal. So I don't care if you can't afford it. I'm going to pay for it. I'm not buying the transcript. We buy transcripts. You know, a lot of our appeals are for free because we just cannot stand the injustice. But the judges know too, well, this person can't pay, they can't afford to appeal. So sometimes but that's where you make law. That's where you change law sometimes, is in the Court of Appeals. So you know, the Court of Appeals, they look at what's in the record. So we tell our attorneys, when you go to court, yes, we're going to court to get a good outcome on the case, but you're really there to create a record. That's why you're there. Because if the judge makes errors, if you don't object, if you don't make your record, then you're going to lose your case at the Court of Appeal level. So it's extremely important for, you know, if you do appeals, to make your record at the trial court level.